Right, number 133, Continental Casualty versus Price Waterhouse.
Ready for court, please.
Good afternoon, Mr. Amity.
Good afternoon, Judge. May I have 3 minutes for rebuttal,
Yes,
please?
you waited a long time, so. Very patient.
I'll be brief.
Okay.
Of course, the general rule of damages in a fraud case is what's called the out-of-pocket rule. It's the difference between what you paid and the value of what you acquired. However, 80 years ago in the Hotelling case, this Court announced a different rule in situations in which a defrauded investor is fraudulently induced to purchase and to retain, and the retention is what's key in Hotelling security.
Why couldn't you be made whole in a derivative action?
Well, we can't be made whole in a derivative action because the math is quite simple. We paid in $143 million. When the fund was liquidated, we received our aliquot share was $111 million, and the net difference of that is $32 million. There's no current pending vehicle that will permit us, other than this lawsuit, to recover that amount of money.
In principle, if there were full recovery in the derivative action, wouldn't that essentially mitigate you out of court in the I mean, you're saying the derivative action doesn't get perfect results, but no action does. But if it did, you would not have any loss in your direct action.
Well, I don't. We've opted out of the class action, and I think that my clients have a right to pursue their remedy that the law provides, which is a direct action. They were wrong. The duty was owed to them. There's no question but that it was breached.
It comes down to whether you have a viable damages theory, then, in your view?
Well, I think there's no question but that we do, and I think that's where
Okay, but I guess before we get there, I'm under the impression that's really the only issue in the case. Am I right?
The issue that the appellate division ruled on was whether my client made a sufficient showing of damages to permit continuation of the action. We say they absolutely did as a matter of summary judgment principles that are longstanding and easy to apply.
What I don't understand, I guess, in this case is the measure of damages. If the measure of damages, I think this goes back to something you've already been asked, but is the measure of damages, the way you calculate damages, differently for the direct action than it would be for the derivative action, or exactly the same?
It's different, Your Honor. And
explain the difference.
The measure of damages for a direct action under Hotelling is the difference between the amount paid in, our paid-in capital, which was $143 million, and the amount we received after the fraud was discovered, which was $111 million.
That's essentially a rescission measure of damages, isn't it?
Yes, it's a rescission measure.
What says you're entitled to rescissionary damages?
The Hotelling case, which said that that's the measure of damages where an investor is fraudulently induced to purchase a security, in that case it was a bond, and there's a continuation of the fraud, which we have here, to retain that security.
And the measure of damages isn't what you lost on the day you acquired the interest?
No, it's not. That would be an out-of-pocket, which is the general rule. And as a matter of fact, it would be hard to quantify that. It's easy to quantify what our damages are here. And the appellate division, we believe, erred in grouping us in with all other investors. Incidentally,
could you have got out of the investment at any time after you got into it?
Sure. We could have cashed out, but there was no reason to.
So you claim basically that Price Waterhouse defrauded you into holding the investment until it was too late?
Absolutely, because some of my clients made multiple capital pay-ins. And they did that based upon the representation that there was a clean audit report and that Price Waterhouse had audited the financial statements, and they had done so in accordance with generally accepted auditing standards, when in fact the evidence is absolutely overwhelming that that did not occur. So there was a continuation of the fraud which induced my clients to retain those securities, and that's why they were holders at the time the fraud was discovered and a liquidation was required. And as a result of that, they paid in $143 million and they received $111 in liquidation. Now, there's other vehicles out there that some
what if some of that loss was due to normal market factors, had nothing to do with the fraud?
Hotelling makes it crystal clear that that doesn't matter. That does not. Hotelling, of course, is a proximate cause standard, and subsequent events under Hotelling do not break the causal connection, the chain of causal connection. As a matter of fact, in Hotelling, there was a complete market collapse of the relevant industry that affected everybody who held securities in that. And the Court of Appeals held, this Court held, that that didn't break the causal chain. It was a factor to be considered. It didn't break the causal chain. And in that case, the measure of damages that was applied is what the investor paid in, $980, versus what he got, which is about $5.80, shows how old the case was. And the difference was his net loss and his recovery. So it doesn't matter, unlike what the appellate division said, that other people might be similarly situated. As a matter of fact, that is the problem with the appellate division's focus, is that they focus exclusively on post-purchase events.
Is it true, to some degree, that what happens in the derivative case will mitigate your damages in the direct case?
Well, that case is on the verge of being settled, and the
Okay, suppose tomorrow it gets off the verge of being settled, and it goes to trial, and there's a huge victory for the plaintiff, and millions and millions come into the partnership. That mitigates your damages, doesn't it?
It doesn't eliminate them. It would be a set-off.
Depends how many millions.
There's no possibility, Judge, on this record that it could ever make up that entire $32 million. As a matter of fact,
but I guess what I'm really getting at is there is some overlap in damages. The recovery in one, theoretically anyway, the recovery in one case mitigates your damages in the other one.
well, as Judge Cardoso,
But put it the other way, if they'd recovered nothing in the derivative case, you'd have a lot more damages.
the fact that a wrong has harmed multiple groups of people doesn't eliminate my right to recover.
So you say mitigation doesn't eliminate your claim.
It doesn't eliminate a claim. As the term implies, it's mitigation. And we've never claimed that if there's some – if we were to – we're not going to participate in the settlement as it currently stands because we're being asked to release our direct claims. But if we did so, the current figure is $29 million, of which we would be entitled to approximately 30%. So we're talking about $10 million. 111 in liquidation, $10 million. If we were a recipient of that settlement fee, we're still out under the hoteling standard of damages, $20 million plus prejudgment interest, which is at the last time it was calculated was $48 million. So, and as a matter of fact,
So what's the test to determine if something's derivative or direct, or does it not matter? Everybody gets to be made whole.
well, the test as to whether something is direct is quite simple from our standpoint. Under Ultramarres against Touche, this Court held that Price Waterhouse, because they issued clean financial statements, clean audit reports that they reasonably anticipated the public, including my clients, would rely on, they owed a direct duty to us. That was their original motion to dismiss. That was long ago washed off. So they owed us a direct duty. They breached it. And then the question here that the appellate division grappled with is what was the measure of damages? And the appellate division held that because there were subsequent events that diminished the value of the fund independent of the original overvaluation, that somehow converted my action from a direct claim to a derivative claim. And that is just not correct under hoteling or under any of the other prevailing cases. And what the appellate division did, and what the error is also, is that they, assuming for the sake of argument that Price Waterhouse made a prima facie showing of a judgment of entitlement to judgment as a matter of law, we say they don't because the Okangu affidavit, which was their linchpin of their damages argument, was predicated on the BDO report, which in turn was never intended as a damages analysis. The nature of the BDO engagement was to do a historical, retrospective reapportionment of the shares, keeping in mind that this is not a conventional purchase. You put in capital, you get and your percentage share, your Class A percentage, is the ratio that your capital in bears to the entire capital. So it's a little bit of a hybrid situation.
So if I understand what BDO was doing, they were refereeing a dispute among various limited partners.
They were in charge of determining what everybody's percentage would be for purposes of liquidating the cash that was on hand.
Did their activity bear on the amount of Price Waterhouse's liability, either in the direct or the derivative case?
No, absolutely not. They were never asked to opine on damages. It wasn't a damages analysis. As a matter of fact, they say in their engagement that's not what they were doing. They were retrospectively readjusting everybody's percentage share to create a formula, a methodology for distributing the proceeds of the estate. Now, putting aside that, let's get to my proof, because that's really the question is, did we produce evidentiary proof in admissible form to create a triable issue of fact? And we absolutely did. The Carmichael report, the first piece of evidence, says that the fund was massively overvalued at the time we purchased it. That hardly need be said. There's really no question as to that.
That essentially goes to liability, that report.
Right. But then the Mala affidavit, which is at 1844 to 1849 of the record, was specifically drafted in response to the Okangu, that's Price Waterhouse's damages expert, was specifically drafted to address Okangu's allegation or his opinion that there was no injury on the date of the investment.
And that embodies the rescissionary damages theory.
That embodies the rescissionary
so,
damages.
Again, you keep telling me the answer is in your favor, and maybe you're right, but clearly the question is, are you entitled to rescissionary damages or not? If you are, you win. If you're not, you lose. That's all there is to it?
We don't win. We get to try our case.
You win this appeal.
We win this appeal.
Okay.
That's correct. And really, so what did Mala say in his affidavit? He said, and it's really common sense, may not even need an expert for it, if the fund is massively overvalued at the time that you paid in your $143 million, as we all know it was, then, and if your percentage share was the ratio of your capital contribution to the total assets of the portfolio, then because that was inflated, you automatically received a deflated percentage share. And that was a direct injury suffered by my clients on the date they purchased or paid in their capital. And he also...
But he did not try... Sorry. Go ahead.
Where do we find in your expert's testimony the figure for what your client's interest, to what extent it was overvalued on the date of acquisition?
That's not in the record, but, Judge, that would relate to the general out-of-pocket. That analysis would only be relevant to an out-of-pocket general
We don't
damages.
need that figure here?
No, we don't, because we're not applying that measure of damages. Only when you're talking about a measure of damages that's the differential between the price paid and the value of what you acquired, out-of-pocket damages, which doesn't apply here, that figure would be relevant. It's not relevant here because under hoteling, all you look at is what I paid in and what I recovered after the fraud was discovered, and the net plus prejudgment interest is my damages. So I see my time is up. I'd just like to...
You have your 3 minutes.
Okay. Thanks so much.
Okay. Mr. Call?
Yes, Your Honor.
Good afternoon.
Good afternoon. This case, at least the plaintiffs want to put their full faith in hoteling, and hoteling doesn't apply here.
Why is that?
Hoteling doesn't apply because hoteling starts out by stating what the basic rule is in New York for an out-of-pocket injury based upon fraud and the inducement, and that is what you paid for what you got on the day of your investment. In hoteling, they then found there to be an exception. They found an exception for one reason and one reason only, and that reason was that there was no way to determine what the values were on the day of investment.
Is there a way to determine it here?
Yes, there's data out there. Indeed, there's data, the kinds of data that their experts have looked at, the kind of data that the BDO experts purported to look at. There's independent data. What they have put in by way, and we heard that Mr. Malla somehow gave us an opinion that allows us to go to a jury. What Mr. Malla said in his reply affidavit, which I understand was intended to go after Mr. Okongu's affidavit.
Well, that's what he said.
Right. His affidavit said, if there is overvaluation, then they overpaid. That's what his affidavit says. Not there is overvaluation to this extent, and this is the delta that resulted.
I think I understand what you're saying, but how do we know as a matter of law that the predicate for hoteling isn't here? You say the predicate is if there's no way to value the more orthodox damages. You don't have somebody who put in an orthodox damage valuation and said it's zero, did you?
No, I don't need. That's not my burden. The burden here was on this motion for summary judgment was for the plaintiffs to come forward with admissible evidence that says on the day of my investment,
it's your motion.
I have a delta,
well,
and they didn't do that.
It's your motion for summary judgment.
It's my motion for summary judgment.
Don't you have to show as a matter of law that the factual predicate for a hoteling type damages is absent?
Well, I did do that.
How'd you do that?
I did do that. One, I showed that, remember, hoteling, we have essentially worthless securities. Here we have people who took out $110 million after the fund was closed down. So we didn't have worthless securities. We have a valuation issue. Two, there's a report that there is, in his expert's report, they say there is independent data available out there for one to perform valuations. And they say that occurs, but they didn't do that. Indeed,
let me tell you, maybe there's something weird that maybe you can explain to me. You both agree that if you could value these interests on the date they were acquired, that would give you your measure of damages. It looks as though a sophisticated expert ought to be at least able to try to do that. The results should favor either your side or the other side. Why has neither side got an expert doing that?
Your Honor, let's look at the affidavits. The affidavit of Mr. Malla, his expert report, and his deposition testimony. He said he was instructed not to do that. He said that he had the expertise to do that he had done it in other cases, but here he was told to do the simple arithmetic exercise. What did I get back from what did I put in?
Which leads the cynical observer to think, they told him not to do it because they didn't like the numbers he was going to get. So why don't you do it and shove the numbers they don't like down his throat?
Because, Your Honor, that's not my obligation. My obligation is to, on a summary judgment motion, to say, look, you have to prove certain elements of your claim. The one element here you have to show is what they said they would show from day one, a distinct, unique injury to them. That is a date of investment injury based upon data in the marketplace. They say the data exists, but they never did the exercise, and they made a tactical decision not to do that. They wanted to go for a larger portion of damage than this presumably would have given them. I don't know because I didn't do that exercise, but that was not my burden. Now, they say today there is enough.
You say that damages can be calculated in the orthodox way?
I understand that they allege that there's data out there that will allow that to happen.
So why don't we let the case go to trial and give them an opportunity to do that? Do they have to put in? Do they have to actually put in a damage number on summary judgment if there is damage there, and you say you admit it can be calculated?
We didn't ask for a specific number. I don't think that that's what's required, but there has to be demonstrated the ability to perform that. They don't have that in this record. You just said they could have performed it and they didn't want to. If it's impossible to perform, then he gets his rescissionary right. I said that they didn't put it into the record. I didn't say that it was impossible.
But isn't that your burden because it's your motion?
No, it isn't my burden. My burden is to demonstrate they put in
to establish your entitlement to judgment as a matter of law.
Correct. And they put in an expert report, and in this case, unusual to New York state courts, we had a deposition of the expert. And we put in an affidavit that demonstrated what their expert was showing by way of damage were the consequences of post-investment monies coming out of the fund. That what they showed is after their investment, they had monies disappear into three pockets. One, it went into excess fees to the partnership. Two, it went into the pockets of withdrawing partners. And three, there was alleged even by the trustee that there was a fire sale of the securities at the end. That adds up to somewhere, depending on who you talk to, and we have a number of plaintiffs here, ends up somewhere in the $90 to $100 million range. I think it was Judge Smith asked this question earlier. They have a derivative claim out there that is going to be resolved, but the derivative claim was for about $100 million. He claims that 33% of that would have been his. That's I think answers that question.
Okay, but let me back up for a minute. I think it's sort of implicit in what you're saying up to now. You acknowledge that in principle he has a direct as well as a derivative claim. You're just saying he can't prove it. He's failed to prove that he has a viable damage.
He does not possess a derivative claim.
I'm sorry, he does have a derivative. Well, but the company.
He possesses a direct claim if, and it's a big if he can show date of investment injury. And that is what he decided not to show. And that was his burden. That's what Justice Moskowitz said.
It sounds like you're both asking the courts to guess whether, in fact, there was or wasn't an injury on the date of acquisition.
No guessing at all.
Well, he says he's out $31 million. Can you prove that he's not?
Pardon me?
Can you prove that he's not?
Well, it all goes back to any number of other factors.
Well, my point is that maybe I'm being too limited to my view, but if you want to get some judgment as a matter of law, you're saying this does not have to go to a jury because we can establish as a matter of law that we're entitled to judgment dismissing this complaint, and here it is. He can't get any damages because we can prove that he's not entitled to any.
That is not my burden. My burden is that he has the burden to show his injury and his damage. It has to be direct and unique to him. That has to be a date of investment injury, and he has not attempted to demonstrate that. That's my burden. My burden was
is it fair to, I keep trying to narrow the issue. Is it fair to say that's really what this whole appeal turns on, whose burden it is to establish a date of investment injury?
Absolutely. Absolutely. I think you find if you look at the two lower court decisions, we first start out with
or in fairness, either to establish it or to establish that it can't be established. If it can't be established, you would agree with him, you can go to an alternative valuation.
Pardon me, if it can't be established, if it was impossible to establish it, then we would possibly run up against totaling. But we have there's another distinction there in hoteling, and that is that there was no second protective action in hoteling for that bondholder. In that fraud there alleged was not won by the company or by somebody working for the company. It was by a third party who sold bonds in the open market, and then propped up the market for a number of years till it collapsed. And as a consequence, the court found there, we cannot determine, there's no data that would allow one to determine the creditworthiness of these underlying these bonds, because they were bonds, they weren't securities. There's nothing there that allows us to do that, and we aren't going to deprive this man of his day in court. That's what that case says.
So,
and here we do have somebody who's out there protecting him. We do have somebody who's brought claims on exactly the same issues of liability, and that person, the trustee, is in an effort to resolve it. What this man would have us do is, let's assume, going back to his numbers, trustee does whatever he does, and he gets as much as he can. He gets it either in a settlement or he gets it in a judgment, but it isn't 100% for whatever reason of what he claimed. He gets then to go after the deficit. Now, if there's a double dip that's grosser than that, I don't know.
But I mean, General Rubber says that the fact that one damage offsets against the other doesn't mean there's no claim.
Right, but General Rubber, many of these cases that are cited by the plaintiff are all motion to dismiss cases. They're motion to dismiss cases where people come in and say, like we did in our motion to dismiss, embedded in this are derivative claims, and they should not be allowed to be prosecuted by an individual investor. What happened here is, rather than the court following Abrams, this court's decision Abrams, which should have dismissed his claim, what she did was she extracted the derivative claims and stayed those and said, go forward and prove your distinct direct injury on the day of investment. That is what they failed to do. Instead, they went back and did exactly what Justice Moskowitz had told them not to do. They came in and showed damages flowing from post-investment fees, post-investment payouts to withdrawn partners. That is not what they were to do. That flies in the face of the derivative cases.
And what was
Abrams, Sloan, all those cases say that doesn't belong to them.
And what was your obligation on your motion for summary judgment? Because it sounds like you don't even need any expert testimony.
I did. I put in expert testimony to show where in the damages they were claiming were derived. My expert's affidavit, his report in his deposition, said, look, this is where this $32 million is derived.
You don't need to show that there's no overvaluation on the date of acquisition.
I'm sorry?
You don't need to show that there's no overvaluation
No, that's not my obligation.
on the date of acquisition.
No, not when that's their obligation to show there's overvaluation.
What about their theory that all the post-acquisition damages did flow from the fraud because they were induced to retain their interest?
Well, then that flies right in the face of the derivative claims. Because the derivative claim, that injury to them is an injury to the assets of the estate. The estate is pursuing those, and that's why I go.
But so the damage is offset. What's the problem? Why can't they produce both two lawsuits, one recovery?
Well, part of it relates to, I think, claim management, and Justice Moskowitz has seen this, in spades below. What happened here is we have had the claims brought against PwC, a number of them. But also there have been claims intra se among all of the plaintiffs as to whose claim has priority, whose claim is superior. Does he possess that claim?
I recognize that you can have a serious claim management problem here, but thank God that's her problem, not ours. We have to decide whether you've got a legally sufficient claim, and then if she wants to stay it because it's a mess to manage with the others, that's different.
I understand that, but the management problem stems, in fact, from there being, less than, if you're to believe the argument you've heard from the plaintiffs, that there isn't a bright enough line there between derivative and direct, and therefore they can flow into each other, they can be intermingled. Abrams says that can't be. That's what Abrams says. But nobody wants these plaintiffs don't want to look at Abrams and take it for its face value. Instead, what they want to do is try to push these cases together. Let's see what we can do when we meld them together. There are no cases out there at summary judgment level that has allowed that to happen. The only cases out there that address this topic are motion to dismiss cases. And those motion to dismiss cases, in some instances, hypothesize that we may have duplication. They may bump into each other. But the fact is, they do bump into each other. They bumped into each other here, and they took the wrong side. And that is precluded by Reno v. Bull, and it's precluded by Hotelling. Because Hotelling says, ordinary. We don't have the exception here. Ordinary. Now and the exception isn't here. The one case they cite, that's a summary judgment case, which is the Primavera case, which I find a little confusing. But the fact is, when they say to Hotelling, they start with the ordinary, and then they find the exceptional circumstance. We don't have the exceptional circumstance here.
Can I ask you a hypothetical? Let's assume you buy a car and you get into a car accident and there's a lawsuit involving the car. You're not responsible. You sue the person who is. When you go to get the car fixed, the guy who fixes the car said, "This is a flood car. You got hoodwinked at the purchase. You paid about $10,000 more for this car than you ever should have because you weren't told that this thing had been in a flood down in Katrina." So now you got two lawsuits. You're suing the guy that sold it to you, and you're suing the guy that caused the accident. There's no problem with that, correct?
No.
You got damages, and they may be a little hard to sort out.
They're different damages.
That's right. And your argument, as I understand it, is that Mr. Amity has to come forward and say what the value of the car was at the time that he purchased it and how much he paid, and he's entitled to that difference from me and nothing else. And if he can't prove that, I win.
That's right.
Don't you, when you bring the motion for summary judgment, have to say he paid $30,000 for the car, it was worth $30,000, therefore he can't collect?
No. What I have to show is, using your example, what I have to show is, oh, by the way, whatever that other number is, the one that this is what was caused after I owned the car when they ran into it. That's what they caused. And that's what that's what the trustee is after. What they caused. That's what he's after. But you've got a defendant on action 2 saying, sure, we destroyed your car, but we destroyed a $20,000 car, not a $50,000 car, and so we're only going to pay you $20,000. That isn't. I'm sorry.
Bad analogy.
I don't think that's the analogy here.
Okay.
We're defending a case with the trustee and as to those posts, and our defense is. Goes to all of the issues. But our defense as to what happened in the years post their investments isn't that, oh, by the way, somewhere back then he should have gotten the money, you shouldn't now.
Okay. Thank you so much.
Thank you.
Mr. Amity, rebuttal.
I, too, would like you to look at the Primavera case, which is Judge Sweet's decision, especially pages 504 and 505 of that decision, in which he happens to say exactly what we've been saying. He rejects any requirement that we have to prove what the securities were worth on the day we purchased them, and he instead applies Hotelling that all I need show to survive summary judgment is the differential between cash in and cash out, and that's 504 and 505. Now, the model's out.
Why shouldn't the general rule apply here? Why should you fall into the exceptional category?
Well, it's not really an exception, Judge. It is the rule that this Court has said applies. It's the damages rule that applies when a defrauded investor purchases and retains a security. So We disagree that it's the exception. Judge Sweet also disagreed that it was exception. It's a different rule of damages. We're not arguing for an expansion of hoteling. We're not arguing for an exception. It is the rule that applies in this type of case. Dr. Mala absolutely demonstrated a data purchase injury. It's common sense. If the securities were massively overvalued when we purchased them, and our percentage share was dictated by the amount of the portfolio, if it's overvalued, a fortiori, we have to have a deflated percentage. He also put the lie, for purposes of summary judgment, to any contention that our damages are the same as the damages sought by the trustee in the Williamson case. He did a very extensive analysis starting at 845 of the record, his affidavit, 846. He talks about the damages across the two lawsuits. He has flowcharts and spreadsheets that calculate to the penny, for purposes of summary judgment, the difference between the calculation of damages in the Williamson case and what we're claiming here. And the reason for that, the reason they're not the same, this Court previously ruled, for example, that most, if not most of the trustees' claims were barred by the statute of limitations. That's your prior ruling in this case. So our claims are not so circumscribed. So it is a completely different action. The recovery is not the same, and we're entitled to be made whole. And the only way my clients can be made whole is through the application of the very basic principles in hoteling.
Thank you very much.